Hi, Adam Cooper here from Cooper Family Law. If you've separated from your spouse or partner, you're probably thinking, what's next? You might be receiving advice from well-meaning family and friends to help you through these uncertain times. Unfortunately, when it comes to property settlements, this advice is often anecdotal and may create false expectations. Now, contrary to popular belief, there is no presumption that assets should be divided equally between spouses or de facto partners. In other words, there's no 50-50 rule in family law matters, nor is there any other mathematical formula for dividing assets and liabilities. What you must realise is that no two relationships are the same, and no two property settlements are the same. The way the Family Law Act determines these matters is a 5-step approach. The first step is to determine whether or not it is just and equitable that any property settlement be made. Now, if you have been in a traditional marriage, traditional relationship through any length of time, or have children, and you've merged your finance and perhaps purchased property together, then the answer is going to be a simple yes. Now, the second step is to determine the asset pool. Both parties must identify all joint and individually held assets and liabilities. Such assets may include property or cash at bank, motor vehicles, company, trusts, superannuation entitlements, mortgages and credit card debts. If there is a dispute as to the value of an asset, then the asset will need to be independently valued. Arguments can often arise about which assets and liabilities should or should not be included in the asset pool and why. This is a complex area of law and wholly dependent on the facts of your matter. Now, the third step is to assess the contributions that each party has made during the course of the relationship or marriage to the acquisition or maintenance of that asset. The court will have regard to financial contributions made at the commencement of or during the relationship, as well as non-financial contributions made by a party, and also the homemaker contributions, such as looking after children or caring for a property. They'll also be considered. No particular factor is given priority over another, and further, non-financial and homemaker contributions are often benchmarked against financial contributions. The fourth step is to assess what is commonly referred to as the future needs of each of the parties. This will include the age of each party, their health, financial resources, earning capacity, and who will have primary care of children. Parties may receive an adjustment in their favour, being a greater percentage of the settlement as a result of their future needs. The final step is that the court will make an order for a property settlement which is just and equitable. And that's the words used in the Family Law Act. In doing so, the court will not only determine the percentage of the matrimonial assets that each party is to receive, but also how those assets are to be divided. In other words, the family home will be transferred or perhaps kept in one person's name or be sold. There might be the need to split superannuation interests from one party to another. It might be necessary for parties to transfer cars or other chattels. There are a range of orders that the court can make. In summary, it's important to remember that there is no presumption of equality. There's no 50-50 rule. Each matter will be decided on its own individual circumstances. For that reason, if you're considering or have recently separated, then it's important to obtain independent legal advice from an experienced or specialist family law solicitor about your likely property settlement circumstances. Thanks, and stay well.